Friends, as soon as we speak with marine insurance, it is understood for us that marine insurance is that insurance which covers all those losses or damages that has caused to the ship, to the terminal, or to the ship in transportation, or to the cargo of which the transportation is carried with, or to that of the goods which is going to be transferred or acquired or held between the parties at different points of its origin and its destination. So, in a way we can say you like this, that my friends, marine insurance is that part of the insurance which would cover all those perils that could take on the sea or that could take on that of the voyage. And in fact, the marine insurance do also include the inland marine insurance. That is, as usually we look at that in the context to that of the marine voyage or marine insurance that is being made out or marine transport is being taken out. To that extent, we shall see that marine insurance is going to be affected. So what we understand from this is that, my friends, contract of marine insurance is that where the insurer undertakes to indemnify the assured in case of loss to the manner and to the extent of which they have agreed between or against to all those marine losses that to the extent of which the marine insurance has been obtained with or to the extent of the marine adventure. So any losses which could take place in respect of any seaness, or I say seaness, I mean to say that the damages that is going to be caused, the accidents that is going to be caused on sea, then such would cover under marine insurance. In fact, Justice Blackburn J, not Cockburn, it is Blackburn J, while deciding the case, that is Lloyds versus Fleming case, he made an observation in defining what a marine insurance is. And to the observation of Blackburn J, he said that marine insurance is a contract of indemnity against all those losses, please underquote with this, against all those losses which is a subject matter, of the policy. And that is, there are certain criteria which are required to satisfy, and only those certain perils or certain criteria which it is being insured with is entitled to that of the indemnity. So whatever that you go on a marine adventure, satisfying those criteria in the adventure, if the loss is incurred in, then that would be called as a marine insurance. So in a way we can say, like taking these two contexts as understanding what a marine insurance is, we can understand in this way, my friends. It is not that all those adventures that what I take or what the perils would take in the marine is not covered under the insurance. It says that it only covers the losses what could have taken on the seas or to that of your ship, but taking this as a consideration, it also says that it is only against those loss which is caused to that of the policy what is included with, and not more than that. So that is what we understand with the marine insurance. And if you look at the nature of this marine insurance, my friends, it is, we see that, or we consider in this way, that all those overseas trades or overseas activities or international trading activities which involves a transportation of goods from one country to that of another country, or from one counterpart to that of the another counterpart by the ship, would fall or cover under a marine insurance. And while transporting through the seas, or when the ship is on the overseas, we see that there are a number of dangerous things which may come in between this. That is during this transmanship. Then when the dangerous are being made, that is especially where a person is transferring his goods or taking his cargo or delivering his cargo to from one destination to the another destination, or where a person is importing certain goods which he would require to upon with, then what is that the person do is that he always expects to ensure the safety of that goods or that cargo which is going to be made from one destination to the another destination. So in that case, it says that is a person, in order to have a safety and to avoid the risk what could have happened to that of the cargo what is taking where, insurance is required. And that's what the marine insurance serves upon to that person who is transmitting ship. That is, where is transshipment what is being caused to that of a cargo, or where the cargo is being made or transshipment is being carried to that of the cargo. For that cargo he wants to have an insurance, and he would take an insurance in that regard. It protects a person to that cargo. Sorry. The other one is this. It is not only the person who is doing is transshipment of cargoes, but also the ship owner. See, when a ship is taking a huge cargo in it, that is in a vessel, the owner of the ship is also equally required for the safe arrival of that ship. He wants to ensure that the ship who reaches its destination, leaves its destination, or leaves its origin and reaches to its destination, it requires that the safety of the ship should be made. So, in order to have the safety of the ship, you may have to cover out various types of the insurances, or you may have to overcome with those risks that could occur during the course of the transit of that ship. So, in such cases, the owner too will have to undergo or take the marine insurance to the protection of his ship or vessel. So in that manner, we shall see that the insurance, especially marine insurance, would cover all these areas. And if you look at the scope of this, the imperative role of this marine insurance, I can say in this way, in fact, marine insurance plays an imperative role covering out against various losses, against several losses that could arise or that could cause a loss or damage through the transshipment. So, when it covers various losses, we can say that comparing to all other forms of insurances to an extent, my friends, the scope of the marine insurance is very wide, and we have also understood this, and this is one of the oldest form of insurance which we come across with. And the development in case of marine insurance has equally enlarged rather than the other forms of insurances. So the scope is very wide. It includes various kinds of perils in it, or it covers out the various perils of what could happen on its transshipment. Like, what is it? Like, it may cover out the man-made calamities. When I say man-made calamities, there could be a pirates on the board, or there could be a theft on the person, or there could be a negligent whereby causing a damage, the crew was negligent and by causing a damage. So in several ways the perils are covered, where those perils are called to be as man-made perils or man-made calamities. The second one also we see is that it covers out the natural calamities. When I say natural calamities, it is not just a man-made but also where the calamities could arise by way of nature, like cyclone it could be, lightning it could be, earthquake or so on, would also be covered under this marine insurances. Likewise, it also includes shredding of your ship or shrinking of your ship. So in these ways, my friends, it covers out with. So also, the general assumption of every person who says that when somebody comes and asks you about with you to that what is a marine insurance, definitely even probably I would also say the same thing, that a marine insurance is that insurance which covers out all those perils which could happen in its transshipment at the sea. But is that only that? In fact, we can say, as I'm speaking to with the scope of this marine insurance, it is not just that which covers the perils of the sea, but my friends, it also, or I can say that it is not just covering out what is going to be made in the sea transit, but also, my friends, under this policy, you can cover several things like something which is going to be here, water, courier, registered post. Look at this. So when I say here, maybe oxygens are being taken through this, we consider that to be as a goods. Or a water, especially to the Arabian countries, waters are being taken through the ship. That is also a cargo for the ship. So waters are also a part of this cargo. It is also been brought under this. Maybe if you are sending a registered post or a courier to that of your known person to that of any other state, then it could be made through this. So we'll not just confine to say this, it is meant only for the cargo or meant only for a particular kind of goods. No, it includes several other things. It is, I can say that is when you are taking this cargo, when you are taking these goods, it may have a combination of all these things also. So in that reason, or in that sense, we can understand that, my friends, that marine insurance covers a very wide area in itself, as issuing the policy to that of the perils what could come across with. And that's how we look what a marine insurance is. And if you look at the elements of marine insurance, this is elements of marine insurance, we can see that as marine insurance is again a contract which is to be made in terms of the Contract Act, and all those features of the General Contracts Act is equally applicable. So the same is also applied here. Like two parties, there should be a proposal, there should be an acceptance, there should be a consideration, there should be a free consent, lawful object. All these elements should be there even in marine insurance contract to say that the contract is a valid one. The second one is insurable interest. When I say insurable interest, who are all having an insurable interest? A owner, generally we say, the owner would have an insurable interest in the property, or we can also say that is to the, when I say owner, to the full value of the subject matter of the property, he has an insurable interest. Or any other person who is a claimant of that cargo or that goods is also equally entitled, or I can say any interestee in that cargo is also entitled to. And in case of ship, the ship owner or any person who has purchased it or the charter of the ship is also entitled to full price of that policy. So he is also a person who happens to hold an insurable interest. And in case of cargo, if you see, the cargo owner of the ship, the cargo owner of that goods, the cargo, or the purchaser of that cargo to the full extent of that cargo, or the amount of what is being paid upon to that of cargo is entitled to have an insurable interest. Or in case of freight, my friends, a person who is to receive the freight, or a person whose amount is still required to be recovered with and it is not being paid, then such person also has an insurable interest in it. So all this person should have an insurable interest. So what we understand here is that when we go to the elements, it should satisfy all those features of the general contracts. A person should have an insurable interest. The person should have acted with utmost good faith. That is, I was speaking to you with disclosure of all those material facts. And he should establish that what is the condition. That is, when I say material facts, he should establish that the facts of risk, what is going to undertake with, the condition of the ship, the route of the ship which it is moving upon with, etc., etc., etc. So all this should be brought under this, that is under the principles of utmost good faith, which is again applied in cases of insurance, marine insurance. Doctrine of subrogation is there. Warranty is there. You have to undergo with the warranties. That is, warranty in the sense, I am to say, again I am repeating the same thing as which I have discussed in my previous slide. It is something where a person, after having taken an insurance, he is required to undergo or undertake some particulars that which he shall do or which he shall not do. So that condition is required to be fulfilled by the person throughout the contract, which an act would be having a negative effect on that of the policy what he has taken with. So to that effect, he has to undergo and follow with it. So in this way, my friends, all these elements has to be satisfied so as to say the marine insurance to be a valid one, the contract of marine insurance to be a valid one. So in this form, my friends, we shall see that how marine insurance can be taken with. So subject to these elements or to the extent of this scope or by its nature, we would understand what a marine insurance is. Further proceeding, we shall look out with the types of marine insurance. This is very important from the points of examination. They may ask you a question like, what is marine insurance? Or define marine insurance and state the nature and scope of marine insurance. Or they may ask you, what is marine insurance and state the elements of marine insurance. Or another important question which could be asked is, state the types of marine insurance contracts with prefixing of the marine insurance. So they can ask you in this way. When it comes to the types of marine insurance, friends, there are several types as I was just addressing you in the discussion. In case of marine insurance, as we see the scope of the marine insurance too, it is very vast, very wide. It is extended when comparing to the other forms of insurance. The scope is very large or very wide. It covers several perils in itself with respect to the marine adventures. So that being the case, we shall also see that the types of insurances what is being issued to the marine perils is also very wide. And one of those are something like, I don't mean to say with the number of insurances that is being imposed, I'm not on that. But the scope of those insurances, what is going to be issued, the degree of the insurances, what is going to be issued by the company is very, very wide in its area comparing to that of the other forms of insurances. And those are, one is time policy. See, time policy is that policy, in a simple way, it is nothing in a brain scratchy point or discussion to go with. It is quite simple. When I say time policy is that policy which is taken for a particular period of time. That is, when a policy is given to whatever the goods that you are taking, whatever the cargo that you are transporting with, or you are carrying out on the sea, or to the ship itself, to the hull itself, whatever it is, but there could be an insurance which could be covered there, saying that for this time period that the insurance is going to cover with. Suppose if I am taking my ship, then that ship would be covered for this period of time. So whatever the subject matter it is, that is, if the insurance is issued to that subject matter, saying that from this time to this time, the insurance covers out the subject matter of which you are taking an insurance, then it is called as time policy. Generally, my friends, when we come with this, the policy when I am taking with, usually that is being taken to 12 months. And also we see under the insurance policy, that is marine insurance policy, is that no insurance can be taken for a period of more than 12 months of time. Or I can say in this way, the insurance will not be honored, or it will not be granted, or the policy will not be issued for a time period which is exceeding more than 12 months of time on the subject matter. So within that 12 months of time, You have a right to take the insurance on that particular or within that span of time. You have a right to take that of the insurance, and if you take an insurance within that span of time, that is within 12 months of time, then the insurance is effective. And mind this, when I take a policy for a marine insurance, in case of time insurance policy or time policy, the time policy would be given only to a particular time and to a particular voyage. Suppose, say for example like this, if a ship is to it has to have a transportation, it has to have a voyage from Bombay to Visakhapatnam. When it wants to have a transshipment ship from Bombay to Visakhapatnam, and again if it is to travel from Visakhapatnam to Goa, now how do it look with? And from Goa to again to Mangalore. If the ship is to have a transshipment ship in these areas, it is not that I can take one policy and say that okay, within 12 months I'll be covering this. No. What it says is that there shall be a difference. See, from Bombay to Visakhapatnam, you have to have a policy. Maybe you may take 5 months or 6 months of time. From Visakhapatnam to Goa, you may require it 90 days. And from Goa to Mangalore, you may require it 2 months of time. Or 10, 20 days, 30 days of time. Whatever it is. So, for each policy that you are taking there, should be different. Maybe at one shot you can take the policy. It is saying that within 6 months or within 4 months of time I would reach here, I would be there, and again after the departure from so and so date to within 90 days I would be having, and from there to Goa to Mangalore I will be reaching within 10 days or 20 days or so. So there shall be a division. That's what we call it as time policy. For each policy that I am taking there, that is, it should specify the date of what I am taking the policy, and that kind of policy we call it as a time policy. Mind this, my friends, that is, any excess days which I take, suppose say I am taking 2 months of time, I am taking this time of which I am going to. Then if I am taking any excess time for taking the policy, then my rate, that is the rate of premium that what I am going to pay upon for the excess days, would be charged at the pro rata calculation. On the basis of this, suppose I say it is within 20 days of time I would reach, but it has taken me 22 days. Then if they want to make that insurance liable, then at the pro rata calculation, they are going to impose you the premium on it. So that is what is called as time policy. The second one is voyage policy. When I say voyage policy, this is again a contract wherein insurance where the subject matter is to the effect that the ship or the cargo is going to be taken from one place to the another place. That is, where the ship is to travel from one place to that of another destination, or when it leaves its origin place, and if it is to reach with a particular destination, then if I am taking an insurance from that place to this place, then we call that to be as a voyage policy. In fact, my friends, where if the contract is both by the time and by voyage policy, that is, both these two can be included under one policy, as in a mercantile usage we do this. So when they have these two, a combination of this, we call those to be as a mixed policies, because it is not just a time I would give. We would also state that which is the route in which it is going to travel there, which is the route in which it is going to reach the destination, even that would be ascertained with. So if the ship or if the insurance is taken stating that the insurance is being made taking that this ship is going to travel in this way, for that also we shall see a voyage policy is taken with. However, we see that the voyage policy must be accurately described. I repeat this. The voyage policy should be accurately described as to the local limits and the risk, that is, in which it is going to travel with, and the risk so specified should be very, very, very clearly specified with. If any inaccuracy in this would take away the right to claim any such compensation or damages which may arise out of those perils. So this is one thing you have to understand here. Then comes the cargo policies or cargo insurances. Friends, when I say cargo, it is the goods which you are going to be carried in the ship. That is where if an insurance is taken to that of the goods what you are carrying from the ship from one place to that of another, for that particular goods what you are carrying through the ship, you can also have an insurance. So when I say you with this, that is when the old term of insurance, we can say that the insurance may cover the time policy, the insurance may cover the voyage policy, and also it could be for that of the cargo. So when a ship is to travel from Madras to Calcutta, when the ship is to travel from Madras to Calcutta, we see this, my friends, that the ship would have a time policy there within this time, that is with maybe I can say within 5 months of time the ship is going to go, and it may also have a voyage. When I say voyage, that is from Madras to Calcutta, it may also specify to you with your route, and it may also contain the cargo of what it is taking with. So it could be again a combination of all these things when you go having an insurances. And the same principle is also again applied with here when I take the policy of all this admixture of these policies, which includes time, cargo and voyage. It should be very clearly known that what is the definite period of the time policy, when it is going to wait, what is the particular voyage it is going to take with, and what is the number of limits, time limits, which you have to have a way for having transshipment of these cargoes are concerned. So to this effect, you can have a combination and also you can have it. Or just simply say for this cargo from this day to this day, or from this time to this time, or to this way, I'm taking the insurance. So you can mix, you can have a mixture of any of these two or any of these three in respect of the cargo what you are taking. So there can also be a cargo insurance. Likewise, we also have a freight insurance. Freight is nothing but the rent payable on that of the cargo what you are taking, or on that of the ship what you are carrying upon with. It could be for the ship also as well as for that of the cargo. So whatever the rent or amount paid in the course of transportation of your cargo or having taken the ship is said to be called as a freight insurance. And here, my friends, generally we say the ship owner or a person who happens to have a right over the freight is one such person who can have a right of obtaining this freight insurance. See, many a times it so happen like this in cases of freight insurance, or in cases of freight I can say. See, that is in a marine insurance contract where a goods is being taken to work from one destination to the another, we see this, the freight would be paid in advance, or it could be paid on the delivery of the goods at the particular destination. Where the freight is being paid in advance, then you will not have to obtain an insurance for that. But where the same freight is required to be paid at the port of its destination, and in between, if it to reach the port of destination, if the peril causes and if there is a loss to that of the goods, then the cargo owner may not pay him the freight, because the freight that the ship that is the goods may itself have not reached to him. So in such cases, it so happened that I may require to have a insurance on that of the freight. So if it is a case of advance, I need not have to worry. But if the same were to be a case where the freight is going to be paid and the delivery of that cargo at the destination, and when such is a contract between, then the problem comes to see that whether the goods would be reached to the particular destination or not, because it is only a contingency. It may or it may not. So in that cases, my friends, that is during the voyage, what is going to take place in that cases, the freight that what I am entitled to, I should be paid upon with. So in that manner, we shall see that the freight, even for the freight what I am taking, I am entitled to. I'll put a simple example here. Say for example, this ship belongs to Mr. A, and A has hired the ship by B. B might have taken the ship and C might be cargoing the ship through this B. Now, what is A is interested? A is interested with the ship. And what is C is interested? C is interested with the cargo that what is taking with. And what is B is interested? B is using the ship of A by paying a certain amount of rent to him. So that rent, how can he collect? That rent could be collected only by way of freight that what he can take. So when I take this freight, it is I am entitled to this freight insurance as. So in all this manner, my friends, we shall see that the insurance can be effected. And apart of this, we shall see this. There are several other forms of insurances we can come in. That is hull insurance. I repeat, hull insurance. H-U-L-L, hull insurance. That's how we say how, when I was discussing to you with the types of insurances, I have mentioned you out with this. What are the insurances that can be covered here? One for the ship, one that is ship includes the hull and freight cargo. These are the three subject matter for which insurance can be availed in cases of marine insurance. So if you take what is an hull insurance, hull means it is the body of the ship or the frame of the ship, my friends. Body or frame of the ship is said to be called as hull. That is, when a ship is in its building or when the machineries are being implanted to that of the vessel, all these things forms to be an hull. So as soon as I say hull, it includes body of the ship or the frame of the ship or even the machineries which it is to be installed to that of the ship, or also the parts or the equipments which are going to be installed to that of the ship or necessarily required for the ship. Example, anchor, which is necessary for the ship, are said to be the part of the ship. So generally when we say hull, we only say it is the outer body of the ship. No, it includes all those equipments. And here it says that hull also covers, that is, if you are taking an insurance, it covers out the entire vessel which is under construction. Because it is not that somewhere in some shed or I'm sorry, in some place I would construct this vehicle or I would construct this ship and bring back to the ocean. No. Ship are constructed in the ocean areas itself. So when I construct the ship in the ocean areas, I would have a right even to have an insurance to that of the construction what I am taking with. And that is what is called as hull insurances. Likewise, my friends, we also have a fleet insurance. Fleet insurance. And this fleet insurance is something, a beneficial insurance I can say. See, what exactly is this fleet? Why it is so beneficial is, friends, fleet insurance is that insurance which covers the number of ships, number of vessels at one insurance itself. Suppose say something like this. If I have a ship, I can take an insurance for my ship. That is for a hull or for the ship. But if I have 10 ships in my name, if I have 10 ships which I am owning with, then it is not necessary for me that I shall take insurance for each and every 10 ship. But instead of that, I can opt for a fleet policy. And I take a fleet policy, it includes the insurance for all those 10 ships what I am. Maybe the ship 1 might be on voyage today, ship 5 might be on the voyage tomorrow, or ship 3 might be on the voyage for another day. It might all have different voyages. It may go on different time. But the insurance is covered to all these things. And one another major advantage what we see in case of fleet ship is this, my friends. See, when I'm taking the policy for 10 ship, if I'm to say, in case if you are taking a insurance for each ship, then you should show that each ship is with a seaworthiness. That is, the ship is capable of taking the seaworthiness. But when it comes to fleet insurance, if out of this 10 ship, maybe 2 ships may not be of seaworthiness. It may not be able to travel at particular areas. Maybe for a smaller distance it can go, that is inland marine insurances. But if it is to travel on the larger areas, that is to the ocean areas, then sometimes it may not be capable of taking the pressure of it. In such cases, the insurance company says that no, we are not going to give you, if you are taking separately, we are not going to give you an insurance or this because it does not satisfy the seaworthiness. So you may have to live away without an insurance. But if it is a case of fleet insurance is that insurance even where if it is not capable of handling, capable of traveling, it also includes that. It never says that no, it is not for me, you cannot take upon with this. That is the advantage that what we can say with. And in paying out of the premium also, I would be paying the premium for all these 10 ships. Once when I pay togetherly a premium for all these 10 ships what I am taking, the premium would also definitely get down or get slow in respect of your payment. And that is the reason why we shall say that fleet insurance is more advantageous than other kinds of. And this is only helpful where I have more than 2 in number or 1 or more in number. That is more than 1 in number if I have, then I can go for fleet insurance. A part of this, we also have a policy called as named policy. Named policy we have, and we also call it as valued policy. Named policy is that, my friends, you, especially in India and of course in the other countries also. If you take in England, Elizabeth, that is, we always say Mr. Dhanush is on its way, we say. That is, Madam Elizabeth, her Elizabeth is on its way. It is about to reach in another 5 days to its destination. That is, in India, what we see, even a small boat for that matter, it is been named with, it is been given with certain name. And that name, Dhanush, suppose say, or Indra, or Arjuna, we call something like this. Or Dharma, we call it as. Is that right? So, or Bhima, we have our own name, which we are fond of it. Or we may also give the name of God or goddesses to that. And if the ship is being made in the name of particular thing, then the name of which it is being given to it can be also taken in the form of. That is, if I am taking Dhanush is coming, I can say the insurance can be taken in the name of Dhanush, which is attached to that of the ship. So, in the form of name, we can also say that the ship can be insured. That is, maybe for, as I then said, for within the not exceeding more than 12 months, you can have a insurance for that ship. So, that is called as named policy. Likewise, we also have a valued policy. When I say a valued policy, that is the value of the subject matter of the policy. Where if I am taking the policy, I can say that this ship is valued to this extent, maybe 10 crore of rupees or 3 crores of rupees, 5 crores of rupees, or this cruise is worth about 60 crores or 70 crores of rupees. Now, when I have valued to certain thing, then to that of the value that what I am taking the subject matter, it is liable. And we also say that, my friends, there can also be an undervalued policy, and the value of the policy is payable according to that of the loss if it is undervalued with. So there is no bar that it has to be valued in this way only. Suppose say, there could be a question on this also. Suppose say, if my ship is worth of 50 crore rupees and I have taken only for 10 crores of rupees. Am I entitled to? Am I, in case of loss of entire 50 crore, am I entitled to 50 crore? No. Because here we see it is only undervalued, it is undervalued, the value of the ship was 50 but have undervalued it 10 crore, then the policy is effective and that policy is payable only to the value of this and not more than that. So in this way, we shall see that there are various policies which we can come across with. And the next one comes as warranties under marine insurance contract. Warranties under marine insurance. Now, what are the warranties? Friends, as I was then addressing to you with or discussing to you with, we understood that a warranty is that where the assured undertakes that he would do some particular thing or he will not do some particular thing. That's what we say. That is, some particular thing shall or shall not be done by him as such. And that condition what is imposed in has to be fulfilled by the person when he is holding that policy. Because of the reason that whereby this condition affirms a negative existence of a particular state of what the insurance is taken. It has a negative feeling. It has a negative character with the facts of what he is doing out with or what he is undergoing with. In a simple context, I can say you this, my friends. A marine insurance, especially in case of warranties, it says warranties under marine insurance contract is something like where if a person has said or agreed to do certain thing, say for example like this, I would go only in the route of this in my voyage. I am warranting, saying that I would do this. Or vice versa, if you look well, I would say that I'll never in any way, I have 4 routes to go with, but never I go in that route because the sea is very rough always there. So I'm saying that I would not be doing this. So what this warranty always says is that it affirms or it negativates the existence of certain facts and says that you are not supposed to do or you are required to do upon with. So in a way I can say you, my friends, warranties are a statement according to which the insured person promises to do the particular thing or promises of not doing a particular thing with respect to, and he agrees to satisfy those conditions. And that is what he agrees to satisfy those conditions are said to be called as warranties. And there are 2 types of warranties here. One is express warranty and implied warranty. There are 2 types of warranties we come across. What is express? Suppose say at the time of taking the insurance itself, if I have contracted saying this that I'll not be doing such particular act or I'll not be taking a cargo of more than 3,000 tons. No, fine. I'm not supposed to go more than that because when the ship is insured, I'm only entitled to take a cargo of not overweighing of 3,000 tons. Now, in this way, I can say that I am expressly agreeing upon that I would go in this form. So, the words are clear, it is expressly made, the condition, the parties have entered into agreement, the phrases of the contract would speak upon that what all the conditions that I am required to do, satisfied to do, or what is not I am required to carry it with or do with. This is we come across with. But in the second instance, the difficulty comes as implied warranties. When it comes to the implied warranties, my friends, even implied warranties are effective as that what I have made expressly to that of the person, that is in the contract. It is effective in the same manner. Only thing what I can say is that when it comes to an implied warranties, the policy when I am taking with, I can say that what I'm entering into a contract with that of the another, maybe Azure or the insurer or the insured, whoever it is. We make a tactically understanding between us, or it is to be tactically understood between us, that is between the parties, when we are entering into a contract. I cannot tomorrow come and say that no, there was no contract because there is no express term, because it is something which says that you are bound to follow even where there is no express term. That is what we call it as implied warranty. And implied warranty, again I say, it is equally liable, equally binding as that of express warranties. We shall see this. And what are the areas which implied warranties works out with? One, as I was just mentioning then, it is seaworthiness. See, when I am taking an insurance, there need not be an express term by the company saying that no, this ship should be of a seaworthiness. No, not necessarily required. Even where the ship of the express conditions is not been imposed with a seaworthiness, but when you are taking the ship on voyage, it has to satisfy the seaworthiness. That is, in a way I can say, the ship what you are taking on voyage should be capable of handling or bearing all those ordinary strains which could take in course of its voyage. Like it could be winds, storms, etc. That is, it should be capable of taking that. And we shall there make, my friends, if two or more destinations are being fixed in, or if you are going to be traveled with, then you should also show that the worthiness. When I was giving you then an example from Bombay to Visakhapatnam to Goa, like 6 months, 90 days or 20 days or so, then the ship should be capable of handling that worthiness. That is, it should be capable of having traveling together or at a stretch for these areas, that is at every stage. And mind this, when I am saying it is from Bombay to Visakhapatnam to Goa to Mangalore, if I am saying that each area which it is going to travel, from Bombay to Visakhapatnam one, as I then said, from Visakhapatnam to Kerala, or that is Visakhapatnam, then from Visakhapatnam to Goa to Mangalore. For each area which it is traveling, it should ensure the seaworthiness. And there may not be any express condition for this. So that is one criteria which you have to satisfy with. And when I say seaworthiness, it is not just that a ship which is capable of taking the strain in the voyage, not just only that. It also says that all those, that the ship which is required to be carried in the voyage, all those requirements which is to be satisfied in respect of the voyage should be equally satisfied with. Like it should be properly equipped, sufficient, and members should be there. The full required officers should be appointed, capable of withstanding the stress and strain of the voyage. All these things are also equally required in respect of seaworthiness. And mind this, my friends, when I say seaworthiness, seaworthiness has no fixed criteria to be understood. There is no such fixed rule which we can say that if these things are satisfied, then you are complying with seaworthiness. No, there is no such fixed criteria in you. See, when I say seaworthiness, seaworthiness may depend on each circumstances of the case. Suppose, say, if I am to travel in a silent ocean, then seaworthiness may not be good enough there. I mean, the ship might be, even where if it is not capable of handling, sometimes it will flow away. It would reach its destination. But where a ship is to go, where heavy storms are there, or rough seas are there, then you have to go, you have to take the worthiness there. So that is a common, that is capable of withholding not a strong winds or not a strong waves that is going to flow in. I'm not speaking on that, but at least in the rough areas it should be. So it all depends with each cases and each area where you are going and each cargo what you are taking with. It all depends upon with that. So that is the reason why we say that That is, when I go testing out the seaworthiness, it depends with that of the cargo what I am taking, the route in which I am going to take, the time of which I am going to travel. All this becomes a factor for the seaworthiness. And my friends, we also say that I'm sorry, we also say this, suppose that is that the ship which is taking should be capable of handling that cargo which it is taking with, which includes the cargo workers. Even that could be, when I say officers, it is not only the members of the crew, but also a cargo workers who are required shall also be equally equivalent. So it is something, a overall way where we can speak upon within seaworthiness. This is the first criteria. That is, this is the first implied warranty. The second implied warranty is the legality of the venture. Legality of the venture is that it is in respect to the risk what you are undertaking with. For every contract, the contract should be legal. It should be not other way unlawful in nature. So the warranty equally implies to the advantage of only where the contract which is carried between you is a lawful in nature. And if it is not lawful, or if it is not carried or conducted in a lawful manner, then you cannot claim any protection under marine insurance policy. So what in a general way I can say is this, or in a simple way I can say is this: marine policies cannot be applied where if it is for an illegal voyage or on illegal voyage. Suppose say if I take the ship for smuggling, if I take the ship for having escorting a asylum, then I'm not entitled to. I'm not entitled to, because it should always be a lawful. A question can be drawn on this. On this issue itself, the question can be drawn, please be sure. So we shall see this, that is, if you are going with an illegal voyage, then also, my friends, we shall see this is not been made. So we can say this, my friends, that is, the ship when used, it should be of for a legal purpose. The third one is, the implied warranty is, there shall be no change of voyage. See, I would have given a destination. I would say that this is the destination which I would wish to go. This is the place wherein I wish to go. See, suppose say a simple example, if I am to give it. If I am traveling from Malleshwaram to, or from Rajaji Nagar to Majestic area by road, I have 4 different routes. Is it right? I would be having 4 different routes to reach Majestic. We see that if traffic jam is there, what we do? We take one way, or hearing the traffic zones, like the alerts of traffic zones, we take the area where we have less traffic. So this is how we can. So we have 4 routes. In any of these 4 routes you can go. But when it comes to the same in case of voyage by ship, it always says that unless permitted by you, you cannot have a change in voyage. Any change which has been caused intentionally without any necessity of having change in the voyage, then such would not be protected with. If I am given a destination that I should reach a Majestic from Rajajinagar only through KR Hospital, Seshadripuram, from Seshadripuram to the Anandrao Circle and through Majestic. If I am to go only in this way, then I have to reach only in this way and no other ways, unless a necessity is being made of when this. So if I am given a particular destination, particular way in which I have to go with, that is, when I am going from Bombay to Goa, or from Bombay to Visakhapatnam, Visakhapatnam to Goa, Goa to Mangalore, I may feel that if I am traveling from Bombay to, straight away, if I say that, okay, I'll travel from Bombay to Mangalore and straight away come down from Mangalore to Goa, Goa to Visakhapatnam, that is not permissible for you. You have to go only in the destination what is been given to you. So that is what it calls for. No change in voyage shall be made. Likewise, we also say there is an implied warranty that there shall be no delay in the voyage also. See, if I have taken for 6 months of time, I should reach there within 6 months of time, because that's what time policy speaks with. There shall be no delay in the voyage unless where it is reasonable on the part of a person for that of the delay. Then if it is delay and if it is reasonable, then of course, as I then said, at the pro rate, the insurance premium would also be collected. But if there is a delay in this, then we can say that no, it is not permitted. That is, the insurance company will not become liable. That is, maybe because of my negligent act, or maybe because of my laziness. If I have caused delay, then any loss which could cause in between, the insurance company will become not liable to it. And likewise, we also have a no deviation clause. So, as I was then giving you there, if I have 4 routes, I have to go only the 4 routes. Or if I say that there shall be no deviation, if I have 4 routes and out of 4 routes says that no, you cannot travel in any of these 2 ways, the optional is left out to you. If you cannot travel in the first route because of some incidences or because of some hazards that are going to take place, then you can go in second route. If they say this, then fine, you can go in that way, but when it is restricted, you are not supposed to go. So this is another implied warranty you can come across with. So in this way, my friends, the implied warranty is applied to the person, even though where there is no express consent between the parties, but still we shall see that the parties are bound by this to follow with the implied warranty. And what are all excused? What deviations can be excused? This is the major thing that we see. See, when it comes to the deviation, see, deviation is something where you are taking a different route in your voyage for the purpose of this delivery or for having purpose of voyaging. That is what we call it as deviation. And the general rule is that there shall be no deviation in that of your voyage. We always say when the voyage has been fixed, when your journey has been fixed in a particular route, then you have to go only in the particular route and you cannot change that particular route. So deviation sometimes becomes a what I can say is that a necessity condition wherein you are required to go only in the common route or the given path what you have given it. That is, if you are fixed in the passage, you have to go only in the passage and no other way you can have it. But if you go, that fits the responsibility of the insurer. It is immaterial that the ship has returned to the original position, to the original destination, by having traveling in a different route also becomes immaterial. Please mind this. I repeat this. See, if the 3 routes are there, 3 routes, that is, I was giving an example from Rajajinagar to Majestic. If 3 routes are there, in out 3 routes, I might has to go only in one particular route. But what you have done is that having traveled from one route, you have taken a deviation to the second route and you might have reached again back to the first route. You might have again brought back to the first route itself. But if any loss is caused by the act of yours, it is not permissible. Or where if you might have reached the original destination of what is assigned to it by taking a deviation in different area, still it is said to be called as a deviation. So when a way is being fixed to you, when a place is being fixed to you, the route is being fixed to you, the passage is being fixed to you, you have to travel only in that direction. That's what the deviation clause speaks with. But there are certain excuses which is being provided for this deviation. That is, first deviation where it could be excused is where the deviation or delay is authorized according to the particular warranty itself. That is, where in the warranty itself, where in the policy itself, they say that no, if there is a traffic jam, if the route has become rough, then you can take this direction. Only in case if the route has become rough, if you are allowed to travel in a different direction, then you are entitled to have a deviation. This is one which is given to. The second permissible time where deviation can take place is that where the delay is caused by the deviation, or where the delay or deviation is being caused, and that delay or deviation is beyond reasonable approach of yours. Like the master of the crew has struck in the storm, where because of his strucking in the storm, the ship might have pulled the vessel in a different direction. It might have taken the vessel in a different direction. Or the crew comes to know that with that strong waves or storms, we cannot handle this. So I have to deviate myself, take a different route, and again reach back to the same thing. Unlike even in air also we see the same thing. We have a traffic zones there. So if I am to have a deviation in that manner, then I am excusable. That is, if I have no any other way, it is reasonably required to have a deviation, then in such cases, my friends, deviations are allowed. That is, any act beyond the control of the crew or of the person, if they are required to have a deviation, you have to establish the act was beyond the control. Otherwise, you are not entitled to. So, if it is beyond the control, then you may have to go for deviation, and that is permissible in such cases. The third one, unlike the previous one, it also says the deviation or delay would also be exempted for the necessary safety of the ship. I might have the cargo, but at the same time, the ship owner should also be protected. Is it right? The owner of the ship is also to be protected. So, in order to have the safety of the ship, or in order to have a safety of the human life, which is required in, then you may require to have a deviation. So, in that circumstance, suppose say there is a breakdown in the machinery. If there is a breakdown or leakage in the ship, and you find that some nearby port wherein a mechanical work could be made for this. So what you do is that if you can reach the entire other part of the area, the ship may sink down. So in that case, what you do, in order to reach the particular destination to get it repaired, you may have to run down to the particular nearby port so that you can have a repair of your ship. So in that way too, if there is a deviation, then you can go ahead with. So this is one another deviation which is permissible. Or if the deviation or delay is due to battery, that is, I'm not speaking battery, I'm speaking with battery. Battery is something which I can say that is imbalances, I can say. That is some kind of imbalances which has been taken place in. So if there is a battery, that is, see, when I'm traveling on the ship, when I'm sailing in the ship, if the ship is quite calm and the sea is the ocean is calm, fine, everything I'm sailing, but immediately the pirates invade to my ship. Now what to do? I have to overcome with those pirates. I have to overcome with those theft what is going to be caused upon with. So in such circumstances, if there is a battery which has been caused to my thing, I may have to have a deviation to avoid those theft or those pirates. So in order to have this, if I take a deviation, it is always excusable. So any criminal act or misconduct, to avoid those misconduct or criminal act, if I am to take a deviation, I am allowed to with. This is another permissible area where deviation can be made. The next one is in order to provide a medical assistance, medical aid, to provide an immediate medical aid to that of a person, where a person is immediately required to have a medical assistance, which is not there on the ship, which is not there on the crew, then we shall say that in such cases too, you have a right of deviation. So my friends, in all these circumstances, we shall see that the deviation can be taken place, and when any cause which excuses the deviation, a part of this will not allow you to claim for the same. So as far as practicable, you have to go in the same direction, same passage what is being given subject to this. And one another thing I can say for example, like I would like to also put in here is that I have a 3 direction and I was supposed to ask with only one direction to move it. I have 3 directions to move, but I am supposed to ask with only to move in one direction. But when I am moving in one direction, if the strong waves pulls me and puts me in the different route, And when I am in the different route, it does not mean to say that anyway I have deviated and I let me back. If any possibility is there wherein I can reach the route of one again, which is nearer to me, which is convenient to me, merely that is after the deviation has taken place, I should resume back to my original route. If I don't resume to original route and believing that okay, I have already deviated or it has given me a deviation, let me go, it is not permissible. So in this way also we have to see deviation has to be understood there, my friends. And finally, I'll also speak to you. So this is how we can say when deviation is excused with. Then we shall see what are the perils of this. Could be a question for short notes or for the main question. When I speak to the perils of this case, I can just simply say this. Peril are those which are covered for such a perils which is going to be caused under the marine activities or marine transshipment. That's what we call it as perils of the seas. Peril in the way I can say, peril of the sea is that what could happen in the course of voyage or what could happen by the act of God or what could happen to the ship or to the cargo by that of human agency. Suppose say if an hazardous act is being committed by the person, then we shall say it is an act of human agency. So when I say peril, peril always refers to an accident or to the casualties what could have been done by nature or by the human agency or by any other mode. That is which an accident takes place with. And it is always that, my friends, the burden of proving the loss as of the peril would always lies on that of the insured. He has to prove that the peril has taken place. Or the burden lies on that of the ship owner. So it is necessary that you shall have a relevant information as what exactly is this peril of the sea. For example, if I am saying with foundering at the sea. When I say foundering at the sea, it is nothing but sinking. Titanic ship, foundering of the sea. If the ship goes missing or where even after reasonable time no news has been received with the ship, we come across with the sea has become rough and we don't know where the fisherman has been found. No fishermen have been found. We are unable to trace where the boat is been gone with. So when we speak, that is, it speaks upon with the foundering of the sea, foundering at the sea, that is sinking of the ship. That is, in the course of its voyage, where if the ship goes in missing and if even after reasonable effort, like again I take the same example, Titanic, which got sank and for several years they found out the ship which has been made. Of course, few were rescued there, that is not a different issue. But the ship went missing and nobody knew where the ship had gone with. That's how we see. Like in such a way, if there is a loss is been caused, then we shall say it is the peril of the sea. This is one peril or forms of peril we can. The second one is shipwreck, destruction of the ship. When I say ship, W-R-E-C-K, wreck. Shipwreck is nothing but destruction of the ship. Where the loss is caused by the peril of the sea, that is, where it so happened that ship gets sinking, maybe because of the ship that it has hit the rock, because of the strong wave it has hit the rock, or because of the strong wave it has collided with another ship which is sailing with, then there we shall say it as a shipwreck. That is, by way of strong wind, strong storm, if it has resulted into the accident, or if it has resulted in shattering of the ships, then we shall call it as a shipwreck. That is, where the ship gets scattered and becomes only a collection of planks, then it is, we call it as the ship as wrecked with. So in such a way too we call, or in such instances too we call it as a peril of the ship. The third form is streading, S-T-R-A-D-I-N-G, streading. Means streading always takes place only by way of storms, not in any other form. I repeat this, it only takes by way of storms, not in any other form. That is, if any accident to the ship is taken out in the ordinary course of our voyage, that is, if the ship is going in an ordinary course of voyage and gets struck in the shallow region because of the storm, we don't know, it gets into a deep sea inside without having knowing into the sand, then we call those to be as a shredding. That is, causing injury to the damage of the ship is said to be called as a shredding. It is, my friends, it could be, that is, but where the crew is negligently, or where the crew acting negligently, which has caused a shredding of the ship, then the company becomes not liable. The insurer becomes not liable for that of the negligence what has been caused by the storm. So in that case, company is not liable, but only when there is no act of negligence, and when the shredding has caused because of the strong storm that has taken place, then you can hold the company liable for that of the insurance which you have taken with. This is one way wherein we can see about the peril. And we also come across with collision, that is striking with one another ship is called as collision, or striking with one another object or rock is called as a collision. Likewise, there could be also loss by fire. When I say loss by fire, goods in the ship could be damaged because of the fire that is being made. But mind this, any inherent vice of which the fire has taken with, you are not liable. Suppose say I am carrying the petroleum product and I have not taken enough care of handling the petroleum product, then I am not liable to that. That's why we say that any inherent vice on the subject matter cannot be giving you a right on this. So it is something, my friends, it covers fire, but where any act caused, that is any fire caused voluntarily in order to avoid or in order to have a gain out of it, then it is not covered. But if a pirates fires out with, then you are entitled to the compensation. In that way, we look upon with, then it could be, there could be a loss by capture or seizure of the ship. That could also be called as a peril of the sea, that is, enemy person may capture your sea, or loss by arrest or detention because of the political act. Say for example like this, when the pandemic got raised in, the ship which was sailing through that of the areas of Japan territories was asked to go, and it was asked to stay there and not to enter in the Japan territory. So by the political actions, if you are going with, then also we can consider that to be, for the delay what is being caused, you can consider to be as the perils of the sea. So these are all what we consider as the perils of the sea. And there are certain things which are also excluded from the perils of the sea. Like, I'll go quickly, that is wear and tear. That is because of its natural decays. Maybe when the ship is sailing continuously in the ocean because of salt water, the metal may become rusted with. So it may lose its weight, it may lose its worthiness sometimes. So any wear and tear, any ship that is wear and tear that has been caused to the loss of the ship, or deterioration in the value of the ship, it so happen, or decay in the body of the ship, or the accessories of the ship, then for that wear and tear you are not entitled to. If the loss is being caused by that, that is because of the wear and tear what is being caused, then it is not covered under the peril of the sea. Or a spring leaking, we say. Generally, see, over a period of time, the ship develops a leakage. When it develops a leakage, a ship leakage, that is, spring gets leakage, that is because of its absorption, then also those things are not covered under the peril of sea, unless where it is due to the accident. Because of the spring getting leakage, if the ship turns or tilts down and causes a damage to certain of the goods which it is going, then also it is not considered to be as the peril of the sea. Or breakage of goods, that is due to the movement of which it has taken place with. Due to the movement, that is while the ship is on voyage, because of the storm the ship waves with. So when it is waving with, if any breakage is caused, then you are not entitled to. But mind this, if that movement has led down, because when I say the very word movement, in every case of marine insurances, we should show the movement. The ship should be on voyage, the ship should be on its sail. If there is no movement of the ship, if the ship is just standing, suppose say, if there is a delay on my part, I am taking certain vegetables in that ship as a cargo, and if the ship has delayed there and if it has stayed there, then you cannot call it as an accident because there is no movement in it. You have to establish a movement in it in order to have a claim of insurance and in order to claim that there is a peril of the sea. So if because of the due to the movement of the ship, if the breakage of the box is taken out with, unless it has been specifically specified that it requires to a standard care of the goods, then it is we cannot say that is as a peril of the sea. But however, my friends, where that movement cause a damage or it is caused damage by a strong waves of the storm or the storm which has caused to the accident, then you can have a right of claim. Mere movement itself is not a thing, but because of the strong wave, if the movement has taken in such a way that which causing a damage to that of your goods, then we shall say that it is covered under the head of accident and we can call it to be as peril of sea. I was speaking to you a case here, Dane versus Pombers case, which I have already discussed to you with. Just remembering you back, a ship owner was laying a ship on the hand, that is in the owner's hand, and the ship was of not a seaworthiness, but the strong waves took away the ship and has caused the damage to the ship. The question came up before the court was before the court was that whether the insurer was entitled to deny the claim. Said that no, this ship, when it was taken away by the waves, though it was of seaworthiness, but when it was taken away by the strong waves, there was a movement in the ship and that movement has led down to the peril and the owner is entitled to the compensation. That's what the case which I have already discussed in my previous discussion or previous slide of my video clippings. I would have said this. The same thing is applied here. Or likewise, inherent vice of the ship. Suppose say by its nature itself or by usage, if it has become, suppose say I am carrying the fruit. If I am carrying the fruit, for how many days it can go? Maybe 5, 10, 12. If you are making with conservatives have been made, then 15 days. But more than that. So it says that where if by its inherent character, that is inherent vice we say, by its inherent character if defect is made up. Or a simple example I can give you. In a box, if one rotten apple is there, that rotten apple kills the other apples which are fit to be consumed with. So one rotten apple in a box, when it takes away the entire box, what would happen? Can you consider that to be as a peril of me? Because of it? See, the other apple can take a strain of 15 days of its travel. But because of that one rotten apple, it has taken all those apples within 3 days of time. So, where there is an inherent vice itself, V-I-C, vice itself, you cannot consider that to be as a peril of the sea. This is one. The next one is death of an animal because of its natural cause. If animals are being carried as a cargo and if it is been of a natural cause, then also. Loss by rats or vermin. We have a case, I already spoken to you while discussing with the causa proxima, referring you a case of Hamilton versus Penrose case, rats case popularly called as. That is, rats enter into, rats bites the water pipe of the ship, whereby damaging the pipe and water enters into and affects the cargo of the vehicle, that is of the vessel, and thereby destroying the cargo which was there in the ship. The question came up whether the company is liable. They said that, the court said that no, it is not liable for the reason that it was not the act of peril of sea. So in case of Hamilton versus Penrose case also we see this, that the act of this person is not liable to with or loss in delay. All these things, my friends, are wherein we shall say that it is not liable. So in this way, my friends, we shall see this, that the perils of the sea can be looked and there are certain exclusions which are excluded from the peril of the sea. And the interest, what we can see, that is how the time of interest in all these perils of the sea is from year to year. As I then said, it will not exceed more than 12 months. And if it is to exceed more than 12 months, then I have to take a further policy of that and to have an insurable interest in that part of the area. So in this way, my friends, I can discuss to you with what a marine insurance is. So a very important chapter we should go with. The next discussion I am to go with you is, which I have left out to discuss at my previous days of the slide, is reinsurance and public liability insurance. Quickly I'll go with this too. See, when it comes to reinsurance, friends, it so happened with the insurance company, like unlike you take LIC or GIC, all these companies I was speaking to you about, with noun companies who are subsidiary of GIC. So it so happens like when company goes on issuing the policy and it goes on entering into a contract with of an insurance, maybe some time it would have number of policies in itself. It would have number of policies. When it has number of policies at one particular stage, the company may feel this. See, every year the agents are given a target that you have to reach this target, you have to reach this target. Fine. The agents try hard to reach the target of what they have, and what they have to, because they want to have a commission more, they want to have a bonus of their commissions of which the company is going to issue it. So they pull out all the money. They come with lot number of policies. When they come with a lot number of policies, at one particular stage it may so happen that the company would feel that the policy is what it has taken, the risk what it has undertaken is beyond the capacity of the company, and feels that no, I cannot go upon with. Then what the company can do is that to retain the risk of which it can bear it, it can hold this, and the balance what is there, what the balance it wants to fill, it can be transferred. See, when LIC had come in, we come to know that, in fact, Malhotra committee also spoke upon with this when we spoke upon with IRDA 1999, IRDA 1999. See, LIC, in a way, it was dealing with several things. It was dealing with several aspects. But when LIC had grown in itself, it could not go with other insurances. So there, the LIC confined itself into one insurance. So in that manner, if you look with, where the company feels that no, it is enough, it is beyond its control or beyond its way to handle out the risk, then it can retain what it can bear with and transfer those risks which it is cannot go with. So to balance out this, what the company can do is that it can transfer it to the other person, and that transfer what is being made is called as reinsurance. That is where the transfer which has been taken place under the contract of insurance, we call it as reinsurance. That is when it is given to the another. Or in a way I can give you like this. Suppose if this A company takes so much of insurance, and later on it finds that too much of insurance it has taken with, and it shall transfer it to some of this. So what does A company do is that A company transfers its insurance to B company to handle this risk, and says that you handle this risk to the extent of this, then such kind of insurance we call it as a reinsurance. And mind this, my friends, when the transfer is taken place, when the transfer is effected, that here the insured or the insurer cannot take more than that of the original policy or original risk that what he has already undergone with. That is in support of an insurance. Suppose I have given to you this amount of insurance, you can only handle to that extent of it, and the liability would only go to that of the original policy itself, and you cannot go more than that. And in India, my friends, as I was saying you this, General Insurance Corporation is the only company which is exclusively doing reinsurance. Exclusively doing reinsurance, and it is confined only to the reinsurance. It takes and transfers it to the, like to National Insurance, or it could be Oriental Insurance or National Assurance, it could be. That's how we see. In fact, the noun companies which we used to say, NOUN, National, Oriental, United and National Assurance, these were called as noun companies. These noun companies were in fact a subsidiary of this GIC, but now because of 1999 Malhotra Committee's report, it has been made independent, and GIC is now given a power only to go exclusively reinsurance, and of course for carrying the reinsurance exclusively, the capital requirement under section 6 is required to be 200 crores. That is, minimum paid up capital of this company should be 200 crores. So with this capital, the company can go exclusively with that of reinsurance, which GIC is doing in India. So because of the increased business which it has enhanced with, and to have an effective need of insurance protection which is necessitated for bringing this, and that's how we see, my friends, that is general insurance has come up with in the ambit of reinsurance. So it says that reinsurance is something, my friends, where the company having grown large, it has exhausted its way, it is further investing or further giving it to the other areas. When LIC was there, in fact, when it was nationalized, it took out 200 companies with. So what is that company is doing? It is company has gone itself into a reinsurance. So it took out the companies, and we shall say that, and it departed, that is, wings were being made, and that's what we call it as reinsurance. This is one discussion, small discussion, which could be asked for short notes. And the second important discussion, very briefly I'll be discussing to you with, is the public liability insurance. In fact, an enactment is also passed on this, called as Public Liability Insurance Act 1991, came into force on 1st April 1991. This is gowning upon the public liability. And today, public liability insurance has become the part of general insurance. What is the ideology behind this? Friends, nowadays we see accidents, especially industrial accidents, are taking too much. Companies are required, or industries are required, to handle out hazardous substance, which has led down to series of accidents. Say we have Italian tragedy, it could be Roman tragedy, it could be, or when it comes to the native state, we see Bhopal gas tragedy, or very recently, about 2 to 4 months back, we see that LG gas leak in Visakhapatnam. See, if you look at with all these tragedies which has taken place in the industrial area, we see there is an endless number of such tragedies have also made out in the past days we have come across with, has led down to the need of public liability insurance, needed for the necessity of public liability insurance, which says that however I may be cautious enough, it says any slightest negligence that is being taken by me, caused by me. See, when a LG gas leakage was there in Visakhapatnam, that does not mean to say that the company had not taken a care. They would have taken the care. But a little bit of slightest negligence or the slightest carelessness that has been caused by them, or little bit of a negligent concern upon this subject. Because when I am walking all the 100 steps, if I am to take 100 steps and I am walking all the 100 steps, I will not be so cautious enough with all the 100 steps. I may sometime go a deviation. I may have small deviation. Or if I am to walk on every day on the same path, I would be negligent in walking. That does not mean to say that I was negligent in that. So it says that if any such negligent act or negligent concentration that has been led you might lead down to several miserables, may lead down to several eventualities, which would have a greater impact on many people, damaging the property, damaging the persons, damaging the environment also. So in that situation, or at this backdrop, we should know and understand why and the importance of public liability. And what does this public liability do? Our insurance covers is that, in fact, the act was being brought in respect of overcoming with these kinds of liabilities. More particularly, it helps out to a businessman while carrying upon his business. It helps out to an organization while is carrying out his business activities. Or at the same time, it also helps us to any small holders, small industries, small shop owners to have a insurance of this to avoid the miserability of the risk what they are going to undertake with. See, beautiful situation is also we can come across with is that, my friends, See, before the Act of 1991, what was the situation? See, if any case of exodus is taken place with, what happens? What would happen? If I'm to say, for example, take the same example of Bhopal gas tragedy. Take this example of this only. Before the Act of 1991, what was the situation? See, if an accident has resulted into a loss or damage to that of a person who are working in, to some extent I can say this, that the workman who has incurred an damage of this gas leak are entitled to claim a compensation and workman. But what would happen because of this leakage? Because of this leakage, we see that it is not just the workman who is going to be affected, but also those persons who are residing within the vicinity of that industry. They have no fault. They have not committed any wrong in that, but still they are being made liable. Now, because of the liability that is incurred in, what would happen? Where would the public go there in such situation? In such situation, my friends, it's said that public liability insurance comes in a way for you. So it helps you in comes in a way. And if you look out with the Act before 1991, you can see this. See, in cases of any such claim which was there, you had only two kinds of remedy to go before the court in cases of public liability. The two, it was not an insurance, because if any liability arises, what was required by you is that either you have to file a civil suit against the person, recover the claim, or the another option was that you have to go by way of petition under Article 226 before the High Court, or under Article 32 before the Supreme Court, by which you are entitled to. That is by way of filing a writ petition or by filing a civil suit before the court, you would have a remedy. And even there, when you go for a civil court or before the High Court or Supreme Court, what was the way in which the court used to decide? The court used to decide whether it was an accident. If so, it is an accident. Of course, the principles of law of torts was applied. That is, whether the person was negligent in carrying upon. And if the owner was negligent in, or if the owner was proved to be a negligent in exercising his functionaries, then he was made liable. Or if a person is handling an hazardous goods, as hazardous substance, then invariably, because hazardous substance has been defined under the Environmental Protection Act 1986. So I should see, or I should show that the hazardous substance what I am handling with is exceeding the quantity, and also the specified notification of central government. Only then I am entitled to, otherwise it is not. So this has led to the need of the public liability insurance, and of course that's how the Act was came in. And of course there the administrative bodies, the controller, and meetings and all those, when it is liable, when it is not liable, what circumstances, all this are being brought under the Public Liability Act of 1991. This is from the industrial point of view. And if you look at from the point of a small shop owners or small industries or small owners, even for them it is beneficial. Suppose, say, if a mob runs away, if a mob, because every day in Bangalore or once, of course, time and oftenly we see that a drunken man goes on rampaging out and damaging the vehicles that are parked outside the road. Now look at this. Who is liable for this? Insurance company says, if there is a specific exclusion, then it says, no, I am not liable, because there was no accident, there was no movement of vehicle there. So in that case, this public liability comes in. Or I will give a simple example. Say, a small shop owner, maybe say your beauty parlor, or for that matter your saloon wala, might have, just for the purpose of his own advertisement, he might have erected a small board in front of his shop. Maybe because of some days, because of resting the holder of this advertisement, the holder may fall and it may injure a workman there who is on the way. Now, when an injury is caused, who is responsible? Can a small shop owner, without any fault of him, that's what we also say, because one of the primary criteria it also speaks is that no fault liability. This speaks with no fault liability too. So when a shop owner for of his no fault, can he be made liable? Of course, reasonable care was required to be taken, no doubt on that. But for a smallest negligence, for smallest carelessness, should he be penalized for more thing? Will it not be more burdensome than that of the other? So in that scenario, it says, my friends, public liability insurance has come, which provides a protection to that of your property, provides protection to that of a bodily injury, provides a protection to that of your business or to that of your organization. So in all this manner, it provides a protection. And what are the types of this public liability? There are three types of public liability, my friends. One is public liability insurance, which is particularly to the industrial risk. Public liability insurance for non-industrial risk, like schools, it could be companies, it could be BPO office, it could be clubs, it could be hospitals, it could be etc. etc. So even these people do also have a right of taking insurance. And the third one is, that is those rights or those types which are conferred under the Public Liability Insurance Act 1991, which is mandatory. Because if a company is to deal with hazardous substance, then those companies, by virtue of the Act of 1991, they are required to mandatorily take the public liability insurance, like unless in case of, as I was then saying, Bhopal gas project. So in these three types, we can understand the public liability, or in these three areas, the public liability insurance can be availed with. And what is the most common coverage of this public liability insurance is, one, where if the claim is arising out of accident or because of injury, because of damage to that of your business or organization, or it could be with respect to that of the arising out of the events of occurrences in that of your business, then you are entitled to have a protection. Or if any act of God you are incurred with the liability, you can have it. Or even with respect to the legal liability, you are entitled to. Or even with respect to the transportation hazard, you are entitled. Or it could also be with respect to the pollution and contamination also. Even for that, you have a right of taking the public liability insurance. And what are the exclusions that is being made under the liability insurance? That is where there is a lapse on your part in preferring legal or contractual liability. You are not followed with, or you are not appropriately gone through with this of the legal or appropriate contractual liability. So in that case, the liability is not liable. Or in the second case, where if the act is intentional, or if the act is for non-compliances of safety, or with the non-compliances with that of a legal provision, the act is not applicable. The third one is where if it is a loss to that of your goodwill, if there is a mental loss, or if there is a damage caused by way of libel or slander, all because of false arrest or defamation, etc., etc., we see. Even there, my friends, public liability cannot be